Hi everyone, and welcome to this case brief presentation by Stephanie Hoppy and Christina Holton on Hardy versus Jefferson Community College. In this presentation, we are going to cover the different aspects that we covered in our case brief and hope that you guys get a really good understanding of this case by the time we're done. So here are the facts. Kenneth Hardy, a Caucasian male, taught in the communications program at Jefferson Community College from May of 1995 through August of 1998 as an adjunct instructor. In the summer of 1998, he was teaching an Introduction to Interpersonal Communication course that had 22 students in it. 9 of those students were African American, 1 was of Asian descent, and 1 was a foreign exchange student from Switzerland. On this particular day, the topic of discussion was how language is used to marginalize minorities and other groups that are oppressed within society. The discussion included many offensive words, including the N-word and the B-word. It was important to note that almost all students in the class participated in the discussion. One African American student took objection to the discussion and complained to Hardy and his supervisors afterwards, stating that Hardy had violated his own syllabus's policy on that prohibited the use of abusive language. So Hardy apologized to the student. Then the student contacted a local civil rights activist, Reverend Lewis Coleman, and Coleman took it upon himself to meet with the college president, Richard Green, to discuss the concerns. So then, a little bit later, Hardy met with Acting Dean Mary Pamela Besser to discuss the situation and the students' concerns. Hardy was able to explain how the class came about and the discussion itself, and solicited advice from the dean on how to help fix it. But Besser actually continued to challenge Hardy on the subject. Besser explained that there had been involvement from the African American community and that the community was expressing concerns that the school's already declining enrollment could be threatened if corrective action was not taken. Not long after this, Assistant Dean of Students Dr. Denise Gray informed Hardy that the situation had been resolved to the complaining student's satisfaction. And within the same time frame, Besser informed Hardy that he would not actually be receiving classes in fall semester, despite a verbal communication in the spring that he would be getting classes in the fall. So the procedural history for this case started like this. The original case was heard by the United States District Court for the Western District of Kentucky in July of 1999. Hardy was the plaintiff, and both the community college, the community and technical college system, as well as Dean Besser and President Green were the defendants. Hardy claimed that the college violated his rights under the First and 14th Amendments to the Constitution, including the right to freedom of speech and academic freedom. He also claimed several state law causes of action, which you can see here. At the same time, Green and Besser claimed that they were entitled to qualified immunity in their individual capacities because Hardy had no constitutional right to use the N-word and the B-word, and they had the right to terminate him for using this language. The district court dismissed all of Hardy's claims against the college, as well as the claims against Green and Besser in their official capacities. The court also rejected the contention by Green and Besser that they were entitled to qualified immunity. So Green and Besser then filed a motion to alter or amend the district court's ruling, but that was denied as well. So then, in 2001, the United States Court of Appeals for the Sixth Circuit in Cincinnati, Ohio, heard the case where Green and Besser sought an interlocutory appeal from the order of the district court. So basically they're saying, hey, we don't agree with what the district court's saying, and we want you to look at it. The issue here had to do with the qualified immunity. So the doctrine of qualified immunity guided the legal question that they're looking at. And in order to determine whether a state actor is entitled to qualified immunity, the court must engage in a two-step inquiry. 1, whether the plaintiff in the civil action had demonstrated a violation of a constitutionally protected right, and 2, whether the right is so clearly established that a reasonable official would understand that he is doing what he is doing violates that right. The majority opinion, written by Circuit Court Judge Ronald Lee Gilman, affirmed the judgment of the district court and remanded the case for further proceedings, and there were no dissenting or concurring opinions stated at this time. The rationale was that the court decided that the use of racial and gender epithets in an academic context relates to a matter of public concern and therefore falls within the First Amendment's protections. And of course, it was limited to academic discussion, and it was designed to consider the impact of certain words upon societal relations. Hardy's speech relates to this matter of public concern, and therefore he satisfied the first of the two-part test. The court also decided that reasonable school officials should have known that such speech, when in this classroom setting, was protected by the First Amendment. So it was inappropriate for them to consider an interlocutory appeal. And of course, assuming that Green and Bessers retaliated against Hardy based on his classroom discussion, such conduct was objectively unreasonable. On the other hand, Green and Besser may defend against Hardy's claim by presenting proof that his contract was not renewed for other permissible academic reasons. So a couple questions that we think are particularly interesting are, in what ways can and should community colleges try and plan for risks that might be involved with academic freedom as it relates to the United States Constitution? We also think it would be interesting to know, are any other cases that are out there where individuals did receive qualified immunity, and how are they similar or how are they different to this case? And finally, we believe that these are the implications that this case has for community colleges. Higher education and community colleges serve as environments for transformative learning, and thus often involve situations where students find themselves in uncomfortable discussions and conversations. We also think that there's a challenge that administrators have of balancing the creativity and expertise of an instructor with the needs of the wants of the community at large. And then we also noted that it should not just be assumed that administrators will have qualified immunity for the actions that they take, so they need to act cautiously and within the policies and procedures of this institution. We look forward to any questions or comments that you have on this case, and we hope you found it interesting and informative as we did. Thank you.